Three names echo through the courtroom: McCullough, McFarland, Harris. Case is dismissed, mercy granted. But something feels unfinished. As the judge turns to one man, a quiet tension builds. Will this be justice or forgiveness?
Court does call the case People versus Jeffrey McCullough.
Over what assistant prosecuting attorney.
Good morning, Judge. Christopher Quinn, appearing on behalf of Mr. McCullough, who's present.
Jeff McCullough, Your Honor.
Thank you.
As the date and time set for preliminary examination, at this time people are unable to proceed.
For dismissal, Judge.
People being unable to proceed, this case is dismissed. The defendant's motion, that is without prejudice.
That's it.
Thank you very much.
Thank you. Court does call the case of Strong Future Homes versus Chanel McFarland.
A man pleads guilty to stealing a backpack worth less than $200. Instead of anger, the judge shows mercy, dropping 2 charges and telling him, "You've got a good heart. Just don't come back." A powerful moment of real justice and redemption.
Morning, Your Honor. Tish Lee on behalf of Ms. Chanel McFarland.
Good morning, Your Honor. Parissa Gazari appearing on behalf of plaintiff.
Good morning.
Chanel Mc-
I have before me a conditional order of dismissal.
Yes.
Yes, Your Honor.
Court every reason I'm satisfied certainly with that, both sides being represented by counsel. I don't need to make further inquiry. This case is conditionally dismissed and I signed your order.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Edward Harris.
Trevor Mabel for the people.
Vaughn Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Edward Harris.
Okay, can you hear me, Mr. Harris?
Yes, I can, Your Honor.
All right, very good. All right, I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of larceny less than $200, the 93-day offense. Upon, that's a count 3. Upon a successful plea to that charge, counts 1 and 2 would be to count 4.
And then there would be a formal motion to dismiss counts 1 and 2 as the people are unable to proceed.
Counts 1 and 2 are dismissed. Set this matter for pretrial.
November 19th at 9 a.m.
That work for?
That's here.
Yes.
Yes. Perfect.
November 19th, 2025, 9 a.m. That is before me. Bond will continue with its conditions.
Thank you very much, Your Honor.
Court does call the case People versus Jeffrey McCullough.
Over what assistant prosecuting attorney.
Good morning, Judge. Christopher Quinn, appearing on behalf of Mr. McCullough, who's present.
Jeff McCullough, Your Honor.
Thank you.
As the date and time set for preliminary examination, at this time people are unable to proceed.
For dismissal, Judge.
People being unable to proceed, this case is dismissed. The defendant's motion, that is without prejudice.
That's it.
Thank you very much.
Thank you. Court does call the case of Strong Future Homes versus Chanel McFarland.
Morning, Your Honor. Tish Lee on behalf of Ms. Chanel McFarland.
Good morning, Your Honor. Parissa Gazari appearing on behalf of plaintiff.
Good morning. I have before me a conditional order of dismissal.
Yes.
Yes, Your Honor.
For every reason, I'm satisfied certainly with that, and both sides being represented by counsel. I don't need to make further inquiry. This case is conditionally dismissed, and I signed your order.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case, People versus Edward Harris.
Trevor Mayville for the people. Vaughn Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Edward Harris.
McCullough walks free, McFarland's dispute fades, and Harris faces his fate. A stolen backpack worth less than $200 becomes the heart of a moral trial. But before this day ends, the courtroom will witness a moment of unexpected grace.
He admits his mistake, a stolen backpack, $200 or less. The judge listens, understands, and offers respect and a second chance. You've been a joy, Mr. Harris. Don't come back here. One sentence that says everything about grace and justice.
Okay, can you hear me, Mr. Harris?
Yes, I can, Your Honor.
All right, very good. All right, I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of larceny less than $200, the 93-day offense. That's a count 3. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. The defendant is also agreeing to pay restitution in a total amount of $130 without a restitution hearing relating to the victim of Natalia Lovo. And that's specifically as to count 1, but he's agreeing to pay that amount. There's also the prosecutor and defendant are agreeing to a sentence agreement of 93 days of jail, credit for 42 he served. There's a note that the defendant is incarcerated at the Washington County Jail as a result of being sentenced on other cases with an estimated release date at this time of March 3rd, 2026. That's the court's full understanding of the agreement.
That is our understanding as well.
All right. The one thing I will do on the form without objection is I will check the sentencing judge waiver box. This is not my case.
Without objection.
All right.
Thank you, Your Honor.
Thank you. All right. You ready?
He's executing the
I thought he was writing warrant.
device of rights.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name. State your name.
Edward Harris.
All right. Mr. Harris, it is this court's understanding that you are going to be pleading guilty to the charge of larceny less than $200. Is that right?
Yes.
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be the sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Right.
Okay, you signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up all of those rights?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
All right. Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily,
yes,
of your own free will,
yes,
and because you believe that you are indeed guilty of this offense?
yes,
All right. On the date of May 3rd, 2025, at the location of 530 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan, what do you do that makes you think that you're guilty?
what was it I did over there?
Larceny.
Oh, I had committed larceny out of a building.
Okay. So did you take something that wasn't yours?
Yes,
What'd you take?
what was it? Backpack,
You took a whole backpack?
yes,
Okay. And that backpack wasn't yours?
no,
And the owner of that backpack didn't give you permission to take it?
no,
And at the time, you wanted to keep that backpack permanently in some way. Is that correct?
yes,
Okay. Okay? Okay. All right. Sir, I do have to let you know that if I accept your plea, between the time of my acceptance of your plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence recommendation or evaluation. You would not be entitled to withdraw your plea. You understand that?
yes,
All right. Counsel, are you aware of any other promises, threats, or other actions which have led to this plea?
No, Your Honor.
Have I complied with the court rule, and would it be proper to accept this?
I believe so, Your Honor, yes.
Yes, Your Honor.
Court, well, you okay?
yeah, this one,
Okay. Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
November 21st at 8:30 a.m.
November 21st, 2025, 8:30. That's before Judge Perry. All right, Mr. Harris, is this the last case you had before me?
yes, it is,
Is it?
yes,
Well, great. I wish you, Mr. Harris, you have been an absolute joy. All right.
thank you,
Always very respectful in terms of the way that you approached, and you got a good heart.
thank you,
Okay. Just don't take any backpacks.
I won't,
You won't do that anymore?
no,
All right. But I wish you all the best, since it's the last time I'll see you.
Okay.
I better be the last time. Don't do anything else to come back.
it will be,
All right. You take care of yourself.
all righty, thank you, Your Honor.
Bond will
Thank you.
continue.
Thank you.
The gavel strikes with measured precision as Judge Quinn opens the day's docket. The first case, People versus Jeffrey McCullough, ends before it begins. The prosecution is unprepared, the state unable to proceed, and just like that, the charges dissolve into the silence of dismissal. McCullough leaves the courtroom a free man, though not vindicated. His freedom comes without closure, his story punctuated by uncertainty. The judge's tone remains calm, procedural, detached, yet beneath that surface hums the rhythm of lives briefly intersecting with the machinery of justice. Next comes Strong Future Homes versus Chanel McFarland. The air lightens, the tension softens. Two women, attorneys on opposing sides, exchange polite acknowledgments before the judge. A conditional dismissal is confirmed. No heated arguments, no raised voices, just quiet satisfaction. Chanel nods with relief. In this courtroom, victory is sometimes just peace after struggle. But then a new name cuts through the calm. People versus Edward Harris. The tone shifts immediately. The judge's voice deepens. The moment feels heavier. Harris, a man already burdened by incarceration, appears via video feed. His crime is simple yet symbolic: larceny under $200, a stolen backpack. But the details matter less than what unfolds next. The plea process begins. The judge ensures Harris understands every right he's giving up. No trial, no appeal, only his word, and the truth he must now speak. The exchange feels mechanical at first, but as Harris admits what he did, something human breaks through the routine. His voice trembles but remains steady. Yes, I took it. A backpack, just a backpack. Not violence, not deceit, desperation perhaps. The courtroom listens. The defense and prosecution confirmed the plea agreement. 93 days, credit for time served, restitution of $130 to the victim. By all measures, this is a minor case, yet the judge's demeanor shifts from procedure to compassion. He acknowledges Harris's honesty, praises his respectfulness, and says words few defendants hear. "You've been a joy, Mr. Harris. You've got a good heart." In those brief seconds, the courtroom transforms. The sterile legal process becomes a scene of redemption. A man, long lost in a cycle of punishment, is seen not just as a defendant, but as a human being capable of goodness. The judge's final words seal the moment. "Just don't come back." It's not a warning, it's a blessing. As Harris nods, the tension releases. For once, justice isn't about winning or losing. It's about learning, forgiving, and moving forward. The courtroom falls silent, but the echo of that exchange lingers. When the gavel falls for the final time, the day's cases may seem small, yet within these walls, dignity was restored, choices confronted, and grace, quiet, unassuming grace, proved stronger than judgment. Because sometimes the truest justice isn't in the punishment, it's in the chance to start again.